video, I'm going to discuss the 4 types of privacy rights that might affect you as a drone operator or as a photographer. Understanding these invasion of privacy claims is the start to appreciating your limitations as not only a drone pilot, but also as a photographer. Hey, how's it going? I'm Andy Contaguglia, a lawyer based in Denver, Colorado. I am bringing you your legal lessons in business. I am here to help educate you about the law in business. So if this is your first time visiting this channel, please like, please subscribe to stay up to date and to get a better understanding about the legal problems that you can encounter while running and managing your business in the US. If you haven't seen my other video about drone laws for 2018, I suggest you watch it before venturing out and getting into some specifics with this video. When we discuss privacy laws, we really need to identify the foundation of it, and that is whether someone has a reasonable expectation of privacy. The reasonable expectation of privacy is an element of privacy law that determines in which places and in which activities a person has a legal right to privacy. An invasion of privacy occurs when there is an intrusion upon someone's reasonable expectation to be left alone. Now remember here, the key is reasonable. And there are 4 types of invasion of privacy claims: intrusion upon seclusion, appropriation of name or likeness, public disclosure of private facts, and false light. All right, so let's take some time and let's get into this. All right, the first one, intrusion upon seclusion. Someone can be held liable if he or she intrudes upon another's private affairs and the intrusion is considered highly offensive to a reasonable person. So this tort is often associated with people like peeping toms, someone illegally wiretapping private phone calls, or snooping through someone's private information. When it comes to using your drone or taking photographs of someone in public, that would not necessarily count. However, using something like a long-range camera to take a photo of someone inside of their home, that would qualify. Or flying your drone up to the 20th story of an apartment building and looking through the window, that would likely qualify. Number 2, appropriation of name or likeness. Now, one could be liable for damages if he or that person's company uses someone else's name or likeness for benefit without their permission. Now, usually this involves a business using another person's name or likeness in an advertisement. Now, in some states, this is even limited to a privacy tort only for commercial use of that imagery. Think of this right like a property right. In other words, a person's name and likeness is treated as that person's property. For celebrities, this is often referred to as a right of publicity. Number 3, disclosure of private facts. Now, this type of invasion of privacy claim must be weighed against the First Amendment's protection of free speech. Unlike defamation, things like libel or slander, truth of the disclosed information is not a defense. If an individual publicly reveals truthful information about an individual that is not of public concern and which a reasonable person would find offensive if in fact made public, that individual could be liable for damages. So for example, someone agrees to allow you to film him undergoing surgery for a documentary created for education purposes, but instead you end up showing that video to or a photograph to the general public or in a commercial theater or on YouTube. This could be considered an invasion of privacy. Number 4, false light. A false light claim is similar to a defamation claim in that it allows an individual to sue for the public disclosure of information that is misleading or puts that person into a false light, but is not technically false. The key difference here is that defamation claims only apply to the public broadcasting of false information, and as with defamation, sometimes First Amendment protections prevail. Generally, a false light claim must contain the following elements. The defendant must have made a publication about the plaintiff. It must have been done with reckless disregard. It placed the plaintiff in a false light. And 4, it would be highly offensive or embarrassing to a reasonable person. A famous example is a 96-year-old woman sued an Arkansas newspaper for printing her picture next to the headline, "Special Delivery, World's Oldest Newspaper Carrier 101 Quits Because She's Pregnant." Now, this woman who was not pregnant was awarded damages in the amount of $1.5 million. So I hope this primer on privacy laws has helped you appreciate some of the limitations on your photography and on your drone hobbies. I think that many people in public have a misunderstanding about what someone is and is not allowed to photograph. Now, I'd be interested in hearing from you in the comments here whether you've ever experienced someone wrongfully accusing you of invading their privacy. In the meantime, I hope that you've enjoyed this video, and again, please remember, please like, please subscribe, so you can stay up to date with these videos and remain educated about the law in business. Thank you for watching. Good luck.